at all. The purpose of an opening statement is to win your trial in the first quarter. And what I mean by that is the most persuasive opening statement is generally a diving board into winning a trial. And the reason for that is we've done studies on this, and in the old days we used to think that we win our trials in the summation. But in fact, that's not true, because if you wait until the end of a trial to try to win the trial, to try to persuade the jury, it's oftentimes too late. The studies have shown, in fact, that most jurors, when they're asked how they felt about the trial once it's over, most jurors say, well, I was convinced right after the opening statement that my verdict would be X or Y. And so, given these studies and given the new trial techniques that are out there, we now know that the summation is generally way too late in the game to do anything about it. They've made their minds up, and if you don't catch them early on the opening, you're not going to catch them at all. So basically, there are different approaches to giving an effective opening statement. And there's no one right approach or one wrong approach. It's up to the individual doing it, because one thing I'll harp on throughout this seminar is that as trial lawyers, we have to be ourselves. Because if you're not yourself, you can't sell anything. The jurors are very smart, and they'll never believe anything that comes out of your mouth. You have to be who you are. And so you have to pick the right style, which is one of the 3 S's that I'll talk about later on. But one of the old-fashioned openings, and if this is the type that you think succeeds, then have at it, is basically to start off with a long introduction. Good morning, ladies and gentlemen, which, by the way, is no longer politically correct. We're not supposed to say ladies. It's good morning, members of the jury. My name is Edward Sapone, and I represent Joe Blow here in this trial. And it's my pleasure to represent Joe Blow, because Joe Blow is a man who's been waiting for his day in court for 3 years now. And Joe Blow and his family are going to explain that later on when they all testify. Now, the role of the defense lawyer, the criminal defense lawyer, is to deliver, if he chooses, an opening statement, and if he chooses to put evidence on. But, we don't have a burden of proof. And on and on and on. And within 5 minutes, the jurors are bored. They don't know what the defense case is about, and they're ready to go to sleep. The laws of primacy and recency are very important in this regard. And that's basically that jurors remember most what they first hear and what they last hear. And so it's very important that in the very beginning, we catch their attention. We don't waste those precious 5 minutes explaining who I am and who Joe Blow is and who the parties are and the role of an opening statement. And before you know it, you get to your theme and they're not even listening anymore. And so some of my colleagues prefer, instead of that sort of traditional, long-winded type of opening, a dark and stormy night opening. And that goes something like this. If I were to bring you back to June 25th of 2005, I'd bring you to an apartment building. And the apartment building would be an old building. It'd be near dilapidated and near condemned. And it wouldn't have a fancy doorman or an elevator. It would be a 5th-story walk-up, so that the residents of this apartment building would have to walk up those steps each morning and each night. And if I were to take you up those stairs to the 5th floor of that dilapidated building, there'd be an apartment number 5A. And if I were to walk you through the door to apartment 5A, you'd see some modest furnishings, and you'd see a dark living room, and beyond the living room you'd see a bedroom. And if I were to walk you through that bedroom, you'd see a man lying in that bed. And you may say good morning to that man, but he wouldn't say good morning back. And the reason he wouldn't say good morning back is because he couldn't say good morning back. Because you see, due to the negligence of this defendant sitting right here, that man could never speak again and can't navigate those steps and can't go out to work and lift his grandchildren and go to the park and do the things that all of us do. Good morning, members of the jury. My name is Edward Sapone, and it's my pleasure to represent that man. All right, so that's basically the the dark and stormy night opening, which sounds good, but it doesn't fit my style personally because I don't really believe in it. Sort of a respectful guy, and I like to introduce myself, although not in a long-winded way because I believe in primacy and recency. And I've tried that. I tried not only criminal cases but also civil cases. And I've tried it on personal injury cases where folks were very much hurt, and it just didn't feel right. And so what I prefer, and what I'm going to teach you folks today, is basically a theme-driven opening. And that's an opening statement without going into all the steps, because I'm going to do that later. I just want to do some preliminary stuff with you first. But it's a theme-driven opening, and that's an opening where I start off very quickly with an introduction and bang them right with a theme, and then go into my theory and hit the main issues and the facts that are going to decide those issues. I then tell them what happened, and throughout this, I'm throwing the theme in. And then I'll go into some absence of evidence maybe, or some light jury instructions, which normally gets folks in trouble, so you have to know your judge. You're not supposed to talk about the law in the opening statement. It's just basically, if we want to be textbook, a recitation of the facts and the evidence they'll learn. But of course, throw in a couple of instructions quickly so that you don't get caught, and then you move on. And because they have to hear these things from the beginning, or else when the judge tells them in the instruction phase later on, it's very hard for them to grasp it. So you want to try to throw it in throughout the trial, not just in the opening. And then I end with not telling them what to do, but suggesting that they know what to do, or they will know what to do. So that's the way I like to do it, and we'll do it more later. But basically it goes something like this. Good morning, folks. Once again, my name is Edward Sapone, and this is Joe Blow. And I respect your time, so I'm going to get right to it. This case is about nothing more than revenge. The revenge that the complaining witness feels because Joe Blow was silly enough to think he could break off the relationship before she was ready to do so. Let me tell you what happened in this case. On June 25th of 2005, Joe Blow, after a 6-month relationship with this complainant, had had enough. He had had enough of the abuse, the trauma, the negativity, and he broke off the relationship. And you're going to learn that that is exactly the reason we're here. Now I go into the theme again, because this case is and always will be about one thing and one thing only, and that's the revenge of the complaining witness. Now, the issue in this case, and then I go into the rest of what I started to touch upon. So you see the 3 different approaches. There's the long-winded intro and who the parties are and what my role is and what the temperature is outside, versus the very dramatic, dark and stormy night where we grab the attention of the jurors right off the bat, versus what I think is something a little more modest in the middle. We don't waste a lot of time. We do say hello and introduce ourselves and then get right to the theme, theory, issue, etc. Now, what is more important in a trial? The summation, where we have the if that's for me, I'm doing a lecture. The summation where we where we have an opportunity to actually persuade and convince and draw analogies, or the opening, which is, I don't know, by some accounts a little cut and dry and boring, where we're just sort of reciting what to expect. What's more important, the summation or the opening? Where have you all been for the last 10 minutes? It's the opening. Remember, we've got to grab them fast. We have to convince them of our story right in the beginning. And does anyone know why we have to do that? We have to do it because jurors, especially these days, are television-oriented. And what that means is they like to go to the movies. They like to rent movies. They like to do that little thing on I.O. and lay in bed and click on the movie. And it's an entertainment society. And so the point is they are going to see this trial like a form of entertainment. Indeed, those benches they sit in are never going to be displayed in Architectural Digest, those hard wooden pew-like benches in the jury box. And so they're trying to get through the day. It's uncomfortable, it's hot, or it's cold. They're sitting with strangers, they're listening to strangers, and they're thinking about their jobs and their children. And so if a lawyer can stand up there and capture them and be entertaining, then she's well on her way to winning. And so here's the point. When we deliver an opening statement, it's pretty much, although we try to slip in themes and theories in the voir dire phase, which I think you're going to hear about in the next lecture, but it's pretty much the first thing they're going to hear about this trial, or at least substantively. The judge gives a